Council. I called this meeting because the Council Reduction Act that we have been litigating now for almost 3 years is a matter of such great public concern that I thought it was important for both the council and the public to have an opportunity to get some updates and for folks to get their questions answered about it. To that end, I have invited Director Wally Dietz from the Metro Department of Law. If you are comfortable there, that's fine, or wherever you'd like to sit, Director. Oh, okay. Do you mind joining us on the dais? I can turn on your mic. So thank you, Director, for joining us. And just so you hear what I said to everyone else, I've called this meeting and grateful to you for being here to provide updates and answer some questions about the status of our litigation against the Council Reduction Act. So if you wouldn't mind introducing yourself, and maybe then you could share a little bit about the history of the Metro Charter as it relates to this litigation. I believe it's on, but somebody can tell me if I have the wrong mic on. Clerk 2 is now on. Okay.
Wally Dietz. Wally Dietz, Director of Law. Okay. All right. Thank you.
Thank you, Director.
I'm the Director of Law. I've been in that position since before the statute that's relevant here was passed, which was, we're now coming up on almost 3 years since that happened. So to the chair's question, I appreciate the opportunity to step back in time because the history of the adoption of the Metro Charter is a really relevant part. And this is something we will make sure the court understands because we've made this argument at the trial court and at the Court of Appeals. Going back in history, there was an effort to consolidate the Metro government where there was a referendum presented to the people in 1958. That referendum failed. And if you read historians, if you read Carol Busey's account, if you read other commentary at the time from the local newspapers, the primary the leading theory for why it failed was because the recommended charter provision had seats for only 21 council members. Members of the Nashville minority community were concerned that if there were only 21 council seats, they could easily be shut out of any representation in this body. It's hard to believe now, based on where things stand now, but back at that time, that was a very real concern, and it was not ill-founded. And so the drafters went back to square one, the framers of the Constitution, and the proposal was revised to increase the number from 21 to 40. That referendum passed in 1962, and as you know, on April 1, 1963, Metro opened its doors as a consolidated government pursuant to state law and pursuant to the charter that was established by the voters themselves. So this number of how many people are in this body, it's a critical matter for all people of Nashville, and historically it's been very important. So this is not just a number. It is an important part of who we are. It forms our history. And it's an important part of this case that it's not something that the legislature should be able to just cavalierly do away with. And so that's the history of the charter.
Thank you, Director Dietz. And there have been efforts in the past to by proposed charter amendments to change the number of council members, right? And the voters of Nashville have weighed in on those.
That's correct, Chair. In 2015, there was a proposal put in front of the voters to reduce the number from 40 to 27. That proposal failed. So It was clear in 1958 and in 1962 and in 2015, the voters of Metro Davidson County wanted to have a council with 40 members. That is the wish of the people as reflected in the charter, which is our Constitution.
Thank you, Director. If you would briefly walk us through the pathway of the case since 2023 and what's happened in the litigation and where it stands now.
All right. Thank you again, Chair. So I think most of you were here when this started. In the spring of 2023, the legislature passed multiple bills trying to impact our governance and our authority. There were 4 separate pieces of legislation. This council bill's one. The takeover of the Metro Nashville Airport Authority was a second. Semi-takeover, but not 100% of the Sports Authority was number 3. And the 4th one was to essentially amend our charter regarding the fairgrounds. We sued on all 4. And at the trial court, we won on all 4. And the lawsuit over the charter revision to the provisions regarding the fairgrounds, the state did not appeal. So that case is over. The 2 cases that are very much alive today are the council case and the airport authority case. By agreement, we stipulated with the attorneys for the state and the Attorney General's office that in terms of the sports authority, we should just let that authority continue to act as it is now constituted, and that any decision about that litigation should be held in reserve after the airport authority case was decided. So that case is in limbo by agreement, and we may or may not have to get back to that case. So where we are now with the council case, on March 9th, the legislature adopted the bill. It was done very quickly, really in almost unique fashion. The Speaker of the House and the Lieutenant Governor personally walked the engrossed bill to the office of the governor, and he signed it that afternoon. So that happened on March 9th. We filed suit within a week. We asked for a preliminary injunction, and we won that injunction on April 10th. So it took us about a month to get that injunction. And in that ruling, the court unanimously agreed that certain sections of this law were unconstitutional because they only applied to Metro Nashville. And if I could just take a little bit of time so that we go back to exactly what was in this bill, because I don't think we should gloss over it, and we're not going to gloss over it with the court. The state sometimes wants to act like, well, that wasn't really part of the bill. It was part of the bill. These measures are extraordinary. First of all, if there's an existing Metropolitan Council larger than 20, the council must be reduced to comply with the law. It takes effect on the date it's signed, March 9th. If the council fails to take the necessary legislative action to effectuate this section before the qualifying date for the next general election, we were in the middle of that election, if you recall. The 2023 municipal elections, people had pulled petitions, they had already raised money, we were in the middle of that election. Then the terms of then council members were to be extended by 1 year. That's extraordinary. The state is saying those of you who volunteered to serve and got elected, well, you're now being drafted to serve another year. I know several members of this body told me not going to happen. But anyway, that was an extraordinary provision in this bill. And that in that case, there would be a special election, not in 23, but in 24, with council members elected for 3 years, and then get back on the cycle that we're about to be on in a year in 2027. Those provisions are extraordinary. They are unique in the history of Tennessee governance. Within 30 days of March 9th, the Planning Commission shall establish district boundaries using the census. Then the Planning Commission presents those to the council. The council must adopt those maps. Must, no discretion. Again, this bill was full of extraordinary provisions that were a gross overreach of their constitutional authority. And now those provisions no longer have any effect. But let's not forget that they were there, because the fact that they are there impacts one of our arguments that we have, and I'll get to that. I'll get to that in a minute. The council was forced on how to vote on a planning commission map. Extraordinary. Members were drafted to serve an additional term. Anyway, it was a gross overreach. The courts recognized that, and we won. And that part of the injunction held. And the parties then argued that the Section B was moot, and we went to the merits. So we ended up having a split decision at the trial court on the merits going forward. But we won, and the state appealed. And then in March, we had arguments at the State Court of Appeals. The Court of Appeals, if you litigate in state court, you know that we are in the middle section of Tennessee, and there is a panel of judges who take appeals from the middle section of Tennessee. But because the middle section is very busy and the other sections are not as busy, sometimes we get a panel from one of the other sections. This panel came from West Tennessee. It was a panel that was not that well versed in Metro history and the charter and issues that we routinely face. I think that was a disadvantage for us, and we lost that appeal. And one of the two questions, we got one vote, but we lost the other two votes. And then on the other question, it was unanimous. So we had to ask permission from the Supreme Court for permission to appeal. As you know, there is not an automatic right of appeal to the Tennessee Supreme Court. A losing party must ask for permission to appeal. We did that, and we asked the court to expedite the decision in the case, and we did something that was fairly bold, which is we asked that the case be set for argument in February to the extent possible. And we had previewed that to the state. They did not want to join in that motion, but they also did not oppose it because they understood that we have timetables we have to meet. We think we're going to win, but if we don't win, we have to be prepared for having an election in 2027 with a vastly different landscape. So when the court granted our petition, which we were very grateful for because that was not a certainty. If we'd lost that, case over, we lose. They acknowledged our request for expedited treatment and said something to the effect that they would do their best to accommodate it to the extent possible. So briefs were filed. Our first brief was filed in November. The state filed its brief on December 19th, right before Christmas. And our reply brief will be due on January 16th, a week from Friday. And we're deep into that now. And so a week from Friday, we will file our reply brief. That's the last brief that will be filed. The court has not put down an order, and I want to emphasize that. But the clerk of the court has indicated that the hearing, the argument on this case will be held on February 12th. That's a docket entry in this case. To the extent you're interested, the airport authority case is also docketed that day. Not necessarily the same time of day. But we're still waiting on an order of the court, and until that comes down, it's not official. But we anticipate, for good reason, that the argument will be February 12th. So we will have a month to prepare the argument, 3.5 weeks to prepare the argument. And we're already working on that oral argument presentation. So that's where we stand time-wise with the case. Did that answer your question.
Yes, I really appreciate that depth, because this has been a long-running thing, and the briefing and argument that we've done has really, really represented Metro well. It's been extraordinarily excellent argument. I can't wait to see our reply next week. I guess if I could ask you to speak, I'm glad you mentioned how alien to the Tennessee Constitution and the law of Tennessee this 2023 Act was, and I guess if I could ask you to speak a little bit to one extra piece of it, which is that it gave the power, or sorry, it purported to require the council to restructure the size of the council, which under our charter and the law of Tennessee is only reserved to the people of Davidson County.
Right. There's a provision in the law that says this body, this legislative body, shall take any action required to implement the reduction to 20 by receiving an affirmative majority vote of those present and voting. That's the lowest possible standard to pass any legislation. It's not 21 votes. It's not a supermajority. It's not 27. It's just a majority of those present and voting. That's a very low threshold. You can't go any lower than that. But that's also mandated. We've argued that that's part of the section that's now moot. We may have to revisit that issue later. I hope not. But again, the legislature was dictating to this council how individual members must vote.
Thank you. I appreciate you drawing that out, and how that this act usurps the power of the people of Davidson County if it stands. So I understand that the home rule provision of the state constitution played a key role in the 2023 injunction, but I understand we've got other arguments in our current litigation. Would you mind summarizing those briefly if possible, and if not?
Sure. I think we've been here before this body talking about the home rule amendment enough. You could probably all talk about it in your sleep. I know I can. I know Allison Bussell and Melissa Roberge can. So the home rule amendment is one of our constitutional arguments. It's not our first one. The home rule amendment says essentially that the legislature, this came about as a constitutional convention where there was a revolt by Nashville and other cities, where the legislature removed office holders, interfered with the operations of local governments, and a constitutional amendment was adopted that said essentially the legislature cannot adopt a piece of legislation that applies only to one local government. There are bits and pieces of it, but that's it in a nutshell. A piece of legislation passed by the state legislature must be general in application. And then you get into nuances about how you slice and dice that. But that's the core argument right there. This case is different than the other cases we have, because we have a constitutional argument that I really think should be a winner, hands down. The state constitution provides for the creation of legislative bodies for county governments. And it says this is the Constitution, not statute. The Constitution of Tennessee says for a county government, the legislative body shall not exceed 25 members, and then there are other requirements. The next sentence in the same paragraph says local governments that are consolidated governments under the Article 11 of the Constitution, meaning metropolitan governments, shall be exempt from having a legislative body as described in this paragraph. We are exempt from the cap on 25, which is how we've survived all this time with a council of 40, because the constitutional provision that says if you're a regular county, you're capped at 25, but metropolitan governments are not. And that is our leading argument in this case. And I feel very strongly that we should win on that. Frankly, it should be a unanimous opinion, but we lost 2 votes in the Court of Appeals, so we know that judges can go against us on this. I found the reasoning in the Court of Appeals to be challenging. And I respectfully disagree with their conclusion. So we think that's a winning argument. And we don't have that argument in the other cases. But in this one, we do. And we're protecting a constitutional right that is crystal clear, black and white, words on a page. So that's our leading argument, and that'll be the first thing we talk to the court about. We have another argument after the home rule and after the exemption clause argument, and that's that the entire case is moot. Courts often look for ways to avoid constitutional issues, and we are giving this court an off-ramp. If they don't want to address these constitutional issues, they could agree that the case is moot, because if you take out subsection B, which is the implementation of all the things we have to do to comply with the act in 2023, where those dates have now expired and this section is now moot, then we say the entire statute is now moot and it cannot be implemented. State vigorously disagrees with us on that, but that's our third argument. Those are our three arguments.
Thank you. Can you share any expectations about the timeline for a decision, if you are able to?
So I'm, in a normal case before the Tennessee Supreme Court, if I'm a litigant, I would expect an opinion within 90 to 180 days. That's a fairly normal time frame. Sometimes it takes longer, sometimes it comes in more quickly. I'm hopeful the Supreme Court will act within 60 to 90 days in this case. They clearly understand that if we lose, there's a lot of work to do to implement this in time to have an orderly election in 2027, and they're sensitive to that. So obviously it's in the court's discretion, and we have to be we have to tiptoe around this a little bit because it's the court and they get to control their calendar and their schedule. But we will let the court know that we would very much appreciate having an opinion within 60 to 90 days to the extent it's possible.
Thank you. And with so many arguments in play, I know this is a little bit of a complex question, but could you share or preview the range of possible outcomes to this case?
All right, there's a fork in the road. We win, case over. We have an election in 2027 with 40 council seats at play with a current configuration of 35 and 5. We win, it's over. Fork in the road number two is we lose. But once you go down that path, if we lose, there are so many different ways we could lose, and there are so many different ways the court may or may not give us an indication of what that path looks like. Part of the tools that we have to implement this law, now that so much of it is gone, that becomes impossible to predict. And so we're not going down that path. I'd encourage this body not to go down that path. Let's wait and see what the court does, and then we will immediately come back in here and discuss our options.
Thank you. Yes. When and if we get to that point, I will absolutely convene this committee as quickly as possible, which, shouldn't happen, but if it does, that's what we'll do. I know you don't want to speculate. I appreciate that, but could you speak to, as a general matter, how our charter governs the breakdown and responsibility between the council and the planning department about choosing numbers and drawing maps?
So under state law and the charter, if we do lose, this body will need to tell the Planning Commission the number. It doesn't have to be 20. It could be a number fewer than 20. And also tell the Planning Commission, are we having at-large seats, yes or no? And if so, what is the allocation between at-large and district seats? This body has that obligation. The Planning Commission does not have the authority to make those decisions, and they should not be put in that position because they don't have the authority, and we will tell them so. And so one of the first things that will come back up is, okay, what's the number and what's the allocation between district and at-large?
And thank you. And if we lose, understanding that there's a whole range in many ways potentially that this case could be lost, what other legal options do we have?
So our arguments are based on state law. There's no federal law component to our lawsuit. The Tennessee Supreme Court is the final arbiter of state law claims. So if we win, it's over. If we lose, it's over in terms of our arguments. And we have put forward every argument that we believe Metro has the right to bring. Could there be other litigation by private parties, by individual voters? Yes. Could there be federal court litigation by members of this body, along with private parties who are voters? Yes, that's possible. Metro would not be a party to that because the courts have made it clear for those sort of voting rights cases, those claims belong to individuals, not to government. So we would not be a party to that. It's possible that we'd relook at the issue to make sure we haven't missed anything, but we've looked under that rock more than once. And we do not believe that we could bring a federal court action, and at this time we would not plan to. But whether other private individuals or elected officers, officials do, that would be up to them.
Thank you, Director. I think we can open up for broad questions, and I appreciate you being here, Director Dietz. I think as long as any members of this committee or other members who are joining us have questions, I want to make sure that we get all those answered. Does anybody have any questions? Yes, Ms. Johnston, let me find your mic. Yes.
So I'm, I guess, a little bit confused because last time there were so many different ways that we were going about it because of the time constraint and what the state, how the state was telling us we had to do it, in those different ways that we would normally do a redistricting. And so in my mind, I don't know like the right way to do it. So let's say we lose, because I just want to be prepared. When we go to tell, because last time when we were talking with the planning department to say what should we do, there was a lot of discussion around, well, how many districts and how many this, and they created multiple maps, and there was a ton of discussion around that and pros and cons, and I think it got a lot really confusing, and I think the public, it was a lot for council members, and we're in it every day. So I'm just wondering, do we, when it comes right down to it, do we tell the planning department or commission, whichever one it is, do we tell them one configuration? For example, do we say, a total of 20 with 15 districts and 5 at large? Or do we give them multiple options to then go on to the ballot for the people to choose? Or do we give them one configuration, they put it together, and that goes on the ballot to be adopted?
Great question. Thank you. Everything about that time frame. I remember sitting over here as the planning department went through that with the numbers and the expected outcome in terms of adequate minority representation and all the things that are important to members of this body. They did extraordinary work. And so they're capable of doing that. In my mind, we're also going to be on a tight timeline, not like 30 days, draw maps, get candidates out there. We're going to have a little bit more time than that, but not, frankly, a whole lot. I think if this body wanted to direct the Planning Commission to present maps at 15.5 and 17.3, that would be appropriate. Just as a matter of professional courtesy to them and their staff, I would encourage you not to go beyond 2 options. But you have the right to ask them to draw those maps.
But can I follow up?
Yes.
So once we do that, as far as what goes on the ballot, because at the end of the day, the public has to adopt it, right? It has to go on the ballot, and that has to be approved by, whatever map has to be approved by the voters, correct? Or no? Or is it just us?
Gee.
Oh, it's only us. Yikes. I thought it had to go on the ballot.
Yes, I mean, I'll just clarify the question, but I think what she's asking is under the terms of the 2023 Act, I think there's many ways we could the court could rule. But Director Dietz, I think to clarify the question, under the terms of the 2023 Act, it requires the council by resolution to change the number. In other words, usurping that power from the people of Nashville.
But if that went away, if that part was, hey, that's illegal, you know what I mean? If they struck that down, normally, does a new redistricting have to be adopted? Or I don't know. I'm confused.
I'll refer that back to Director Dietz.
Yeah.
If you'll give me a few minutes, I need to go back to the state law on this because there is state law that's applicable to new maps drawn after new censuses.
Okay.
So let me try to find that provision and I'll look. I hope to get you an answer tonight.
Okay.
So we'll put a pin in that. I've seen several hands. I think Mr. Cash, I saw first, Benedict Parker, Suara. Yes, Mr. Cash. Oh, let me find your mic. There you go.
Thank you. Maybe I'm going to ask a similar question, but in a different way. So if we lose and we have to change the makeup of council, I mean, it essentially kind of like creates a hole in our charter unless we do something to explicitly change the charter, right? Like there was stuff that was in there and the state law from 2023 kind of made it invalid, right? There would be stuff in the language of our charter that state law had struck down, right?
Okay, as a matter of basic law, the state can override provisions of our charter. And so,
Right.
But I really do not want to go too far down that road.
I understand.
Because this is we do not know whether subsection D, now section 4 of the statute is going to be alive or not. We don't know if the court's going to give us additional guidance. We don't know if the court's going to tell us you need to follow the state law that comes into play every 10 years. We don't know, but
Okay.
but there are provisions of our charter, and in this case, there would not need to be necessarily a vote of the people to do it, but there could be. It just depends. You get into a conundrum.
But my original question was, state law kind of invalidates part of the existing charter, right? And so, like, there was something in there about 40 members, and that if we lose, that becomes inaccurate. And I guess I'll ask it where I get the not wanting to go down that road too much, but I guess, like, if we are in that position and we have to come back, as Chairman Cap said we would, will you help us with ways to, like, I guess, repair our charter so that it's not just this hole with a, like, asterisk saying, state law, change this. Yeah, I don't know. I guess.
Look, I understand the concern, and we definitely will come back. We may have some indication from the court after February 12th, which way they're leaning and what their particular concerns are. And that will help us prepare for any ultimate opinion. And it's just, at this point, it's really, I think, counterproductive to talk about measures. But I understand your concern. It's a valid concern. But again, if we lose this lawsuit, the charter provision for 40 members is void.
Right. But it's still there, and we haven't had a charter referendum to replace that language. So,
the words on the page
I'm not asking like what we do right now, but will you prepare us in the future if that?
Absolutely will help. We'll be here to talk through those options.
This is mostly I guess this is a question. I think I know the answer, but I want to get it on the record or see if I'm wrong. So our charter as is defines two types of council districts, or two types of council members, I guess, a district council member and an at-large council member. And I'm assuming it defines what those mean. For example, when we were going through this discussion, 3 years ago, 2.5 years ago, like there was some discussion about like rather than having countywide at large, having like super districts where you had 4 kind of at large over a fourth of the county. The charter would, if we were to do something like that, if we were to have an at large is currently in our charter defined as countywide. Is that accurate?
Yes.
Yeah. So if we were to do something like these, I'm not proposing that we do, but if we were to, that would have to go through a charter change and couldn't be a part of our the legislation that we create to create the 20 council or whatever number council districts, right? I didn't say that. I didn't ask that well.
You could create, I think the term that was used in 2023 was super regional council members, where
Right.
you divide the county 4 ways into quadrants and have at-large members from there.
But aside from that legislative stuff that we would do if we need to, that would be something that would have to go through a charter referendum process. Is that correct?
I believe that part would, yes.
Thank you.
Thank you, Councilmember Cash. Councilmember Benedict next, Parker, Suara, Prepti. Go ahead, Ms. Benedict. When I find your mic.
Thank you,
ahead,
Chair. Thank you, Chair, and thank you, Director. You know, by God, I hope we win, and quite frankly, I think we'll win. I think in preparation of the scenario of if we don't, that we need to be clear with the voters that we want to hear from them, that they created this government and we need them to create any new government that would be required should we lose. Again, I don't expect us to lose, but I also think we need to engage the public as quickly as we can on that. And from the charter amendment side of things, I think we've heard from the voters, as you said earlier, 1962 and 2015, and both times they've upheld that they want a 40-member council. So my concern is that I think that the writers of this legislation at the Hill were trying to take away the voice of the voters by saying the council can adopt the new makeup by resolution. Because I think if we put this to a charter, to a referendum, it will fail. I think no matter how many scenarios we put on a referendum, I think the voters will reject the idea of reducing the council. Now, to my question about that is who in 1962, I'm not sure it's very different now, but who would be responsible for advising the council on how many members it should be for us to then take to the public and get engagement on? Is that a function of Metro government? Is that a function of the council office that serves us and advises us on everything else?
I would say you have various options. Let me comment briefly on your first 2 comments, and then I'm going to answer your question. In terms of getting public actively involved, could not agree with you more. And frankly, you were preaching to the choir when it comes to your committee chair, because he and I have discussed this extensively. And that is something that Chair Cap is very focused on. And so that conversation will start immediately, and there will be a process of communication there that will need to start immediately. And the law will be part of providing information to give some answers to questions that are being asked. And we'll have more definition. But in terms of your question, I think you could go to a variety of resources. I think you could ask the Charter Revision Commission to give you recommendations. I think you could have recommendations coming out of this committee. So I think you could certainly employ the able counsel and people in the council office on that. So I think you have multiple resources available to you at that time. And obviously we're here to pitch in as well.
Thank you for that. I think, Chair, just one more question that was in my head, and I want to make sure I get it. And
Please.
It popped out. Welcome to the age that I am. Put me back in the queue. Oh, I know what I was going to say. From a timing perspective, 5 weeks from now for oral arguments, potentially 60 to 90 days. So the earliest that we would probably hear from the Supreme Court, obviously it's at their will, would be mid-April. And so then thinking about the timeline, then we move in, even if we immediately come out with this, we're in the middle of budget season. April 1st, the budget comes out. In May, we meet for the budget 4 days a week, right? 4 nights a week. And then we go into June. And then what if the thing doesn't come out until July? And my concern is, again, that engagement with the public. I want to make sure that the public understands what the chair is saying and what you're saying, and that I believe all of us agree with. We want the public to be engaged as soon as possible. And I think the concern of waiting until April or May is that we're going to be so occupied with other things, preoccupied with other things, that I have a concern about our ability to engage with the public as their elected representatives today. So I don't know if you have any feedback about that timeline, or Chair, that may be a question for you.
I'm happy to jump in, but Director Dietz, I don't want to stop you from if you've got anything. So I appreciate that, and if it becomes an unfortunate duty of this committee to take community engagement, I'm committed to making that happen as robustly as possible. I don't want to invite defeat by visualizing concrete scenarios of what that community engagement would look like. But if we have to, if we're in that scenario, which we shouldn't be, but if we are, I think we have an opportunity to do something that wasn't done in 1958 or 1962. Those charters were submitted to the people, but they were not formulated in any sort of way that we would recognize as democratic. I think if we have to, in this body, adopt some kind of new structure, I'm committed to, and I think it's prudent and right for us to make the consultative front end of that process as community-driven, consultative, and democratic as possible. The final vote, if the Supreme Court tells us has to be in this room, maybe that's what it'll be. But if on the front end, I would contemplate having this committee convene outside of this room in the community every night for days on end if we have to, until all questioners and commenters have exhausted all questions and comments. I mean, that not a happy thing to contemplate, but I think that if we have to do it, then we'll have to do it, and I'm committed to doing it.
Thank you for that, Chair. And I think I'll end my questions and comments with the same thing I started with, which is I hope we win, and I think we're going to win. So all of these scenarios are in the mindset of engaging the public. But again, I hope that we're not going to need to move forward with anything other than what the voters have reaffirmed what they would like to see. So thank you.
Thank you, and I'm grateful to you for asking that. And I think part of the reason I wanted to convene this meeting is so the people of Nashville can know that we are contemplating victory, and we're also contemplating doing any kind of thing we have to as democratically as possible, because this is the people's charter. It's not our charter. It's not the state legislature's charter. It's the people of Nashville and Davidson County's charter. Councilmember Parker, I will mic you up.
Thank you, Chair, and thank you, Director Dietz, for being here for the update. And I just had a question. In following this case, watching the appellate court oral arguments, it seemed like both sides kind of had to pick one piece of their overall case and just focus on that. It seemed like it was, shorter than I would have expected for a case of that magnitude. Is that typically how the Supreme Court oral arguments work as well, where you kind of have to identify one element and hammer that home, and then sort of the rest of it's in the filings and the briefs and whatnot? Or do the Supreme Court offer like a little more time for multiple points to be made?
Thank you, Councilmember. It's totally in their discretion. This is the kind of case where just the number of questions they ask may require that the time be extended so that their own questions can be answered adequately. So, but that's totally their call. There is a time limit, and but in a case like this, it's not unusual for them to extend it, or for them on the front end to provide a longer time period for argument. But when we get a scheduling order, we'll see.
Thank you. And the sort of the case history that's out there for folks to review potentially, is that they filed first or we filed first, and then how many back and forths have there been?
So on the briefs, the losing party, which we unfortunately are, files the petition framing the questions, and then if that petition's granted, we are the appellant. We filed the first brief. The state filed their one and only brief on December 19th. We come back with our reply brief on January 16th. The briefing is closed, and we go argue.
Thank you.
Thank you. And next, I have Councilmember Suara, and I will turn your mic on. Go ahead.
Thank you, Chair. Thank you, Director, for being here. And also thank you to your team for an awesome job getting us this far. So I'm optimistic, like everybody else, that we're going to win this. We got great team working for us, so thank you. Some of the questions that I wanted to ask has been asked, so I'll try not to ask them again. And I do agree with everyone about the idea of making sure that the constituents of voters' voices is reflected in whatever we do. The first thing I wanted to ask, I think somebody may have asked but not say specifically, is I know you're doing the arguments in February, but do we know typically when there will be a response from the court?
So the normal time frame for an opinion is 90 to 180 days. In this case, I believe they understand the need for some prompt action, which in this context, I would hope they would give us an opinion within 60 to 90 days. The council member Benedict's question, I mean, there's a chance we get an opinion in 30 days. I don't think that's likely, but it's possible. If they will meet, they will vote, they will assign the opinion to one of the justices, and they could agree on an opinion very quickly. It could be 30 days. I think it's not unreasonable for us to encourage them to give us an opinion within 90 days, maybe 60 to 90. We'll sort of tread that water as we get into the argument itself. But one of the arguments that we've made in our brief is that we need time. We need time. And we need, frankly, some guidance from the court about what our authority is and what our options are to implement this law where so much of it has been gutted because the time frames have expired. So we'll see.
Thank you. My other question, I think, is something that a lot of us have been chattering, asking. We're not really sure, and if you can make some clarification, if it's possible. This comes to the definition of council term, that because we all hope we win, and that makes it very clear and easy for everyone. In the event that we don't, and we now go to this 20-member body, can you please explain what happens with the two-term limit? How does that apply to current members serving? Is this a new council because it's now a new 20 people? Do people have the option to run again if they so choose? And that applies to both the regular council member as well as the at-large. What is the definition of that council term? And how does it impact people current serving? If you can allude to that, I appreciate it.
Thank you, council member. Yes. Our guidance to this body 3 years ago was that the two-term limit would still apply. And we haven't revisited that question. I'm sure we'll be doing that in the next few weeks, but we concluded, both inside and outside council agreed that the two-term limit still applied. It didn't matter if the districts were drawn in a different way. The position is the council membership. And so our opinion was the two-term limit still is in effect. Thank you.
Anything else? Councilmember Suara? Okay, Councilmember Prepti, I had next, and then Councilmember Weiner.
Answered all my questions.
Oh, great. Okay, Councilmember Weiner, go ahead.
Maybe. Okay, I thought somebody had glued my microphone to the case. So this is truly a hypothetical, and I hope it doesn't come to fruition, but if it does, I have a question. If we lost and a private party decides to take it up a rung and file federally, obviously that's going to delay the case. It's going to delay everything we have to work with. That said, would someone, and who would that someone be, that would potentially file an injunction for a delay? I mean, what happens when we're juggling moving it up a rung, should that happen?
If we lose the case and there is no federal court injunction, we must comply with the law and proceed to implement the law. If there is a federal court injunction, then that stays the enforcement of this law, then we are bound by that court order.
That helps. Thank you.
Are there any other questions or council members who wish to ask a question? So at the bottom of the queue, Councilmember Johnston's question is coming back up. Director Dietz, do you have any further info or guidance on that?
I would ask for professional courtesy to give me a little bit of time to respond, because this is an unusual situation, because the state law, as you know, has procedures following decennial census. We're not in that space. And the question is, does the state law still apply? We think it's the best analogy we have, but it's just not as clear as we would like it to be. So if you would give me some time, I will respond to you, but also to the chair and this body with the answer to that. It's a good question. I'm sorry, I'm not ready to answer it tonight.
Sorry, I just turned your mic on, Councilmember Johnston.
Oh, sorry. I was just saying that's fine, absolutely. We're all in uncharted territory, so I just want to have some clear expectations of how we're supposed to proceed, because we are going to have sort of a short runway, and so.
I'm glad you asked the question, because we need to be prepared to give you very clear advice there. Because again, the one thing that should not happen is that all of these issues are punted to the planning department, because they don't have jurisdiction to do that.
Any other questions for Director Dietz? Thank you, Director, for joining us. Very grateful for your work on this and your time tonight.
Thank you, Chair. Thank you, everyone.
Oh, sorry, there's a question. Councilmember Prepti, yes, go ahead.
Thank you. Sorry. I've just been mulling over this, and it might be a more appropriate question for later on down the line. But in particular to the scenario that Councilmember Cash was discussing earlier, my question goes towards, in the event that worst case scenario and we are required by resolution to restructure the metro government, and that restructuring, this council body contemplates utilizing regional at-large members. We've discussed how that would ultimately require a charter amendment, but under the statute, would council have the authority to enact those changes for regional at-large through the resolution mechanism that is required under the statute?
The provision of the law we're talking about is subsection 4 of TCA 71113, section B, subsection 4. It says this. This is after all of the extraordinary steps that I just walked through at the very beginning of my comments. The Metropolitan Council shall take any legislative action required to effectuate this section by resolution, achieving an affirmative majority vote of those present and voting, regardless of any provision of a charter or private act to the contrary. So we are arguing, first of all, we and the state agreed that subsection 4 was moot. The state has changed its position in the last brief it filed with the Supreme Court. So this is very much up in the air. We will argue vigorously that section's not alive, but at the same time, we frankly are going to need some guidance from the court about how we get from A to Z. We've already told the court we cannot guarantee, this is in our brief, we cannot guarantee that a referendum to reduce the number from 40 to 20 or something shorter, less than 20, would be adopted by the voters. There's no guarantee of that. We can give no assurance. And the court can't make people vote a certain way or another. So that's part of our conundrum. And that's part of, it goes back to the arguments that this law should be struck down because we are put into a situation where there may not be a proper way to get from A to Z. And so we'll be making that pitch to the court on February 12th.
Thank you.
Thank you. Any other questions? Next on our agenda is discussion of future business and scheduling. I'd like to open this up. I guess my suggestion would be that we schedule another meeting for updates after February. I guess we're looking at the 12th. We don't know for sure. But if any other members of the committee have suggestions for next steps, I'd like to open that up. Councilmember Parker and then Benedict, and your mic is on.
I guess, Chair, do you have a sense of what sort of regular business this committee needs to tend to as well as this matter? Like, are we looking at 26 for anything? I guess I would like to know that to think about our year.
Yes, thank you. I mean, I don't know that that's up to me necessarily. I think historically this committee considers charter amendments that are proposed by any council member. In keeping with that past practice, we, in this committee earlier in the term, went through lots of stuff that was sort of held over or pending or like historically had been proposed. So we went through a lot of that in 2024. And so if anybody's got an appetite to do that, I'm here for it. But this committee has done that piece of its historical work. But yes, I think if anybody proposes, any council member proposes a charter amendment, we're obliged to consider it. We have, I guess there are 3 elections between now and the end of the term on which we could conceivably place a charter amendment by, council action, August, November, or I guess August of 2027 would all be hypothetical opportunities for that. So I think absent this huge pending question that implicates almost everything else in the charter, we would be, having lovely discussions about, updates and improvements to the charter. So I think my instinct is to try to get some sense of where we are at with that, because subsequent changes to the charter probably should be made in light of what the council looks like. But that doesn't mean that if somebody files something that we wouldn't consider it, and I think we'd have to call a meeting to do it. And then, council members who want to suggest charter changes, this group will have to, convene to discuss them. So if anybody's got an appetite to do that, I will certainly facilitate that meeting. Other things equal, might make sense to see where we're at a month from now or 6 weeks from now and take it from there would probably be my instinct, but I'm certainly open.
I mean, that sounds like a reasonable approach given the timeline and what we've heard from Director Dietz today. I think the 4 to 6 weeks and revisit the question, probably more like 6.
Thank you. Councilmember Benedict, your mic is on.
Thank you, Chair, especially since I'm not on this committee and we're talking about new business. I guess I just want to reiterate that should we know something prior to February 12th, it sounds like you're committed to the second we know something, you're going to call a meeting. I doubt we'll know something before then, it sounds like, but I just wanted to reaffirm that.
Thank you. And yes, if we learn something, I will work with the vice mayor and the council office to make sure that everybody's available who needs to be. Schedule a meeting of this group that all council members should be invited to as soon as humanly possible. I think it might make sense to have a date on the calendar, though, for updates and questions because, we'll probably be in the Supreme Court in February, maybe sometime early March, just get some updates. But, open to what the committee thinks about that. I see Suara Cash Wiener. Go ahead, Councilmember Suara.
Thank you. I actually think that I would prefer us to be 30-day out post the argument, especially since we're thinking we might get something in 30 days, 60 days. And so I don't see the need to come right back after the 12th, February 12th. But if we give ourselves about 30 days out, then we can, maybe by then we might even have an inclination whether we'll get an early response or not. But 30-day post February 12th is what I would like to see on the calendar.
Thank you. Councilmember Cash.
Thank you, Chair. I was on the committee in 2024, and we talked about a number of possibilities. We were given handouts that had like dozens of past submissions, and I think there were kind of like 3 or 4 that we focused on. As I believe you recall, there was a kind of a desire to like leave the since the transit referendum was coming on the same election, that we kind of wanted to not muddle the ballot and leave that there, leave that kind of with not lots of things for people to have to sort through and decide on. So I do, like, I don't want our calendar to totally wait on what's going on with the Supreme Court case and the lawsuit. And I don't know that when we need to have a meeting, but I do think we pretty soon need to know that if we want to submit either one of those that is on the list and we've already kind of at least had some discussion on, or something new, that we kind of need a calendar. I don't know, you said the August 2027. I don't know that I'm concerned about that, but I think for like August and November of this year, we need to know like what if we're considering submitting one, we need to know kind of what a timetable is. I don't know that we need to have a meeting about that, but I think we need that information about like, if we want to submit one, you know, it needs to be, you know, kind of backtrack from the election dates, because we can't just do it, you know, 2 weeks before the election. There's a process that we have to go through, and, you know, I think the Charter Revision Commission is part of that, and committee is part of that, and the full council is part of that, and we want to be able to, you know, have rich conversations about the possibilities. So even if we don't have another meeting in the next month or before the Supreme Court case is reviewed, I would like us to get that information so it's clear kind of what the calendar looks like, or what if we want to take some sort of action, that we are informed of the calendar to do so.
Thank you. To that point, quickly, I've sort of spoken with the council office about those deadlines for my own information. I think we can just work together to circulate what the deadlines would have to be for consideration, and we could probably just get an email out about that this week. But I wouldn't want to create a schedule for ourselves that precludes consideration of anything we need to consider. But I think Councilmember Wiener had wanted to be in the queue, or did I miss that? Okay, yes, go ahead.
So that was part of what I was going to say, is that there's a pretty prescribed schedule for what we have to look at. And I know that's something that'll be shared. So that's thing number one. Thing number two, I'd like to ask Director Dietz a question first before I ask my third question, because it'll predicate what I ask. In the event that we do have the oral argument February 12th, what would you actually be prepared to share with us, or what questions could you answer at that point? And is it premature for us to meet at that juncture 30, 45, 60 days later without a resolution from the Supreme Court?
So we will, as a matter of professional ethics and respect for the court, not comment extensively about the oral argument. We may be able to have some high-level observations about issues the court was interested in. That also will be in the media. So you're going to be able to read it in the media publications in Nashville, because they will be reporting on that. And you can watch argument yourself, and you can see what the court was interested in, but it would be disrespectful for us to continue to litigate the case after we've argued it in the court. And so you're gonna hear very little from us. It's possible we get the impression that we're gonna win the case 5-0. It's possible it goes the other way. But what's very unclear is what the methodology would be if we lose. And so that's why I keep saying we should wait until the opinion comes and then start planning at that point.
Thank you. That predicates my next comment. And that's going to be, I don't know that there's necessarily a path or a need for us to meet with respect to this one issue within the 30, 60 days. I fully believe that we should take the lead of Director Dietz and his staff because they're extraordinarily capable and excellent at handling what we need. And so I would opt that as it relates to all other issues that we have in front of us that could potentially be charter revision proposals, that we follow that path with our prescribed schedule that we have already put forward. So that would be my thought. Thank you, Director Dietz, that helped.
Thank you, Councilmember Weiner, and I think quickly I believe that the Supreme Court argument will probably be streamed online, and council office is indicating that that's the case, so we can make sure that council members have that link to watch the argument if they want to. Right, but you can watch it live if you choose to do that, or attend in person. I believe Councilmember Johnston had a question, and your mic is on.
Yeah, and just very quickly, I was exactly what Councilmember Weiner just said is I don't think we need to meet about this again until after they make a decision, and even after that, we may not need to. But if we want to meet to talk about and we already have an ongoing spreadsheet of issues, if we want to add to it and narrow it down so that we have something that we can move forward should we need to, that's one thing. But again, I just don't think we need to meet about this again until after there's a decision made from the Supreme Court about this particular thing.
Seeing no one else in the queue, I may attempt a synthesis of the comments and maybe suggest that we have just a general scheduling and non-Council Reduction Act related meeting maybe in early March. We may have updates by then. We may have to change the date of that meeting. We may have to call another meeting, but are folks generally comfortable with that? Am I seeing anyone who's not? Thank you. I'm seeing some thumbs ups. So would folks want to risk trying to pick a date now, or should we just work through the council office to pick a date? Okay, I think we got consensus on that. So just stay tuned for that. And thank you all, because I think we probably have to think about some other options as well. I mean, some other issues as well. Are there any other questions or items that anyone has before we conclude today? Well, thank you all for being here. Thank you again, Director Dietz, and we're adjourned.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information on this and other programs, visit nashville.gov.